Members, welcome everybody. Today, the 24th of August, 2022, our section 194 inquiry continues. I want to welcome the members here at M46 and members on the virtual platform. I want to welcome the public protector.
Recording in progress.
I am aware that the team is on its way. I also want to welcome Advocates Bauer and Advocate Mayosi, to welcome members of the media with us, the entire support staff, as well as the members of the public who are already on their various platforms to join us. Today we have a new witness that is going to be with us. And in that regard, I'm going to recognize both Advocate Bauer and Ms. Fatima Ibrahim. Advocate Bauer.
Good morning, Chair. Good morning. Advocate Mayosi is going to be dealing with today's witness.
Thank you, Advocate Bauer. Just to make sure that we connected, Mr. Honorable Mika Mashaule, can you hear us?
Yes, I can, Chair.
Thank you, the technician on board. I now recognize Ms. Fatima Ibrahim to do the preliminaries and introduce to us the witness.
Thank you,
Ms.
Chair.
Ibrahim.
Thank you, Chair. Ms. Mogaladi, can you hear me?
Yes, I can hear you.
Okay, thank you. Ms. Mogaladi, you have been invited, subject to the provisions of Section 16 of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act of 2004, to appear before this committee as a witness and to answer questions in respect of the committee's inquiry into the removal of the Public Protector, Advocate Nkwebane. Please be informed that by law you are required to answer fully and satisfactorily all the questions lawfully put to you, or to produce any document that you are required to produce in connection with the subject matter of the inquiry, notwithstanding the fact that the answer or the document could incriminate you or expose you to civil proceedings or damages. You are, however, protected in that evidence given under oath or affirmation before a House or committee may not be used against you in any place outside of Parliament, except in criminal proceedings concerning a charge of perjury or a charge relating to the evidence or documents required in these proceedings. Please be aware further that in terms of Section 17(2) of the Powers Act, a person who willfully furnishes a House or committee with information or makes a statement before it which is false or misleading commits an offence and is liable to a fine or to imprisonment for a period not exceeding 2 years. Ms. Mogaladi, you will now be required to take an oath or to affirm that the evidence you are about to give is truthful. Which do you prefer between the oath and the affirmation?
I prefer an oath.
Okay, may I please ask that you raise your right hand and repeat after me? I swear that the evidence I shall give.
I swear that the evidence that I shall give
Shall be the truth.
shall be the truth,
The whole truth.
the whole truth,
And nothing but the truth.
and nothing but the truth.
So help me God.
So help me God.
Thank you, ma'am. Chair, the witness is now duly sworn in.
Thank you, Ms. Fatima Ibrahim. Welcome, Advocate Mbofu. I had indicated that you will be joining us a bit later.
Thank you, Chair. Yes, there was a problem. The police were not at the entrance or something. Thanks.
Thank you.
Apologies.
That's okay. I now recognize Advocate Mayosi.
Thank you, Chair. Ms. Mogaladi?
Advocate Mayosi.
Yes. You've made an affidavit for this inquiry with the assistance of the evidence leaders, correct?
Correct.
And you stand by the contents of your affidavit, is that right?
Correct.
So the evidence leaders drew your attention to charge 4 of the motion that this committee is busy with, right?
Correct.
Tsepo, can you put charge 4 on? Now, charge 4 is a charge of misconduct and incompetence. And one of the allegations made in charge 4 is that Advocate Nkwebane, the PP, as we shall refer to her when we proceed, is guilty of misconduct in that she intimidated, harassed, and or victimized staff. Alternatively, she failed to protect staff in the office of the PP from intimidation, harassment, and or victimization by the former CEO, Mr. Vusi Mahlangu, in particular in relation to the staff mentioned in that charge. Do you see that?
Yes, can you see that?
And there in paragraph 10.4 of that charge, your name is mentioned as one of the staff members who were affected by this alleged conduct, correct?
Correct.
And in paragraph 10.3, Tsepo, Ms. Lesedi Sikele is mentioned as one of those staff members. Is that right?
Correct.
Now, you say in your affidavit that you made for this inquiry with the assistance of the evidence leaders that some aspects of your affidavit relate to Ms. Sekele. And you say that she has made a confirmatory affidavit in that regard, correct?
Correct.
And she has indeed done so, made a confirmatory affidavit in relation to those aspects. Is that right?
Correct.
Now, in paragraph 5 of your affidavit, you deal with, shall we say, 5 things, which you then say you are going to deal with more fully in your affidavit. And you say there, as a precursor to those 5 issues, that that is you have personally been threatened with disciplinary action by the PP for not meeting the deadlines for submitting reports when I was going through traumatic circumstances due to various things, right?
Correct.
And what you say there in the first instance is that you were threatened with disciplinary action in relation to, you were threatened with disciplinary action by the PP for not meeting deadlines for submitting reports when you were going through traumatic circumstances, one, right? And secondly, you say, or when you had explained that objectively, based on workload and other factors related to that, the deadline just could not be met, right?
Correct.
Thirdly, you say Mr. Vusimahlangu, acting at the behest of the PP, also issued you with an Audi letter. The PP has previously instructed the then acting Chief Operations Officer, Ms. Ntoriseng Motsitsi, to take disciplinary steps against you when you did not meet a deadline in November 2018, and after the PP was not prepared to entertain your explanations as to why the deadline could not be met, right?
Correct.
And you say, in addition, the PP instructed Mr. Mahlangu to take disciplinary steps against the COO, the ACOO herself, Mr. Abongile Madiba, and Ms. Sekele, correct?
Correct.
Mr. Abongile Madiba, you say, passed away in July 2021, right?
Correct.
But in addition to that, in addition to the things you mentioned in paragraph 5, you also say in paragraph 6 that Ms. Sekele, Mr. Madiba, and yourself had disciplinary proceedings preferred against you by the employer, that's the PPSA, in the circumstances about which you will say more in this affidavit later on, right?
Correct.
Now, the three of you were found guilty, and we'll go into this in the affidavit when we go later on. The three of you were found guilty in those disciplinary proceedings, and you were sanctioned. I don't want to go into that now because we will go into that later, but for present purposes, please answer the following question for the committee. Given that you were sanctioned and you were served with your sanction and you were disciplined by an independent chairperson, and you served your sanction, do you believe that the fact that you were disciplined was part of victimization / harassment / intimidation in the organization?
Thank you, Chair. I do believe that the manner in which we were charged amounted to victimization in the organization, and the reason being, it is my view that had the former CEO, being Mr. Vusimahlangu, and the public protector objectively and fairly looked into the matters that led to the disciplinary charges against us, and they conducted a fully investigation into the circumstances, more in particular, the fact that the investigations in question, myself, Ms. Sekele, and Mr. Madiba were not involved in those investigations from the beginning. So had they conducted those investigations, they would have arrived at a different conclusion. And I also believe that had the entire circumstances been taken into consideration, it would have been an opportunity for the organization to try and address some of the challenges that led to the outcome of the report. And as part of the investigation, if we were held to have violated some processes or had not complied with some of the investigation processes, then we would have been held accountable and we would have been we would not feel that we were being victimized had the matter been looked at holistically. And particularly for myself, I would elaborate in detail that at the time I had just taken over the branch in question, so had all those circumstances been taken into consideration, a different conclusion and outcome might have been arrived at by the organization. So I feel that the fact that the former CEO and the public protector rushed to take disciplinary steps against us and suspend us amounted to victimization. And I think I would also elaborate in detail that throughout my stay in the public protector, and according to my knowledge, so far we have been the only 3 people who have been disciplined for reports that have been taken on review. So I feel that that on its own amount to victimization. Thank you.
Just before we proceed, we need a bit of volume from you. You might need to just reposition yourself closer to the mic so that we can hear you much louder than we can. So that everybody else can hear. Can you just...
Is it better, Chair?
It's getting better now, yes. So if you can keep at least at that level, thank you very much. Advocate Mayosi.
Thanks, Chair. So you believe that the fact that you were subjected to disciplinary proceedings in the circumstances in which you were subjected to them amounted to victimization, as you've just explained, correct?
Correct.
So just going to the background that you provide in your affidavit. So you joined the PPSA in December 2000, right?
Correct.
And you were appointed as the chief investigator in 2004. And then you occupied various positions and roles from that time, right?
Correct.
And then in September 2012, that's when you were appointed as an executive manager to the Early Resolution Division, right?
Correct.
And then in April 2012, when the Early Resolution Division position was merged with the Executive Manager Service Delivery position to form the Administrative Justice and Service Delivery Division, that's when you became the Executive Manager for that division, right?
Correct.
And then can you just briefly explain for the committee what the AJSD division's functions were?
Okay. Administrative Justice and Service Delivery Branch's main role in the Office of the Public Protector is to conduct investigations into allegations of administrative and service failure. Embedded in that, it's simple and complex investigations. These are the majority of the cases that have been received by the public protector. It is what is at times being referred to bread and butter issues that affect an ordinary member of the public. At head office, those are the majority of the cases that have been received by the public protector. And also part of the responsibilities of the Administrative and Justice Administrative Justice and Service Delivery Branch is to identify systemic challenges based on some of the complaints that we received, and to conduct systemic investigations. And also in some instances, we might identify areas where we need to conduct an in-depth investigation to determine the root cause or root causes of the number of complaints that we might be receiving at any given time. And also part of the key responsibility of this branch, the Public Protector has a responsibility in terms of the Public Protector Act to resolve complaints by alternative dispute resolution, being mediation, conciliation, and negotiation. It is part of the responsibility of this branch based on the nature of the complaints that are being investigated by the AJSD branch. So with the branch that I was managing, it was responsible for dealing with those complaints that are received and investigated at the head office of the Public Protector.
So in paragraph 12 of your affidavit, you set out the structure of the AJSD branch, right?
Correct.
And from that structure, at that time, you had 2 chief investigators reporting to you, right?
Correct.
And then based just on that structure, you were presiding over more or less 21 people in your division, correct?
Correct.
And then in your affidavit in paragraph 13, you say that in about the middle of October 2018, you were approached by the then Chief Executive Officer, Mr. Vusimahlangu, to help and manage another branch, which was the Good Governance and Integrity branch at the time, right?
Correct.
You say in paragraph 14, you were a bit apprehensive with this request to act as the executive manager for GGI, which is the Good Governance and Integrity branch. Can you just tell the committee more fully why you were apprehensive?
Okay. I was a bit apprehensive because, as I would elaborate underneath, I was requested to manage that branch over and above my substantive position being the Administrative Justice and Service Delivery. And the nature of the matters that are being dealt by the Administrative Justice and Service Delivery require attention. Most of them are urgent based on the nature of the complaints. As I said, they are mainly bread and butter issues. And also, importantly, due to the high volume of cases that have been processed by the branch, I was under a lot of pressure to finalize some of the current cases that I had. That included some of the backlog cases that was not finalized within the turnaround time, so finalizing HASC cases being 12 months. And also at the time, we had embarked on the process of systemic investigation based on the high number of complaints that we had received against several government departments. So in terms of our plan, we wanted to conclude those systemic investigations by the end of the financial year. And so I was busy at the time based on my substantive responsibilities in AJSD. Furthermore, GGI deals mainly with complex cases in the Office of the Public Protector that are related to governance and conduct failures, procurement irregularities, as well as allegations of violations of the executive code by members of the executive. And at that time, based on the presentations that were made at the backlog, I was aware that GGI had a lot of backlog cases. And also at the time, the GGI did not have a full-time executive manager who was managing the branch. So I was a bit apprehensive based on mainly those two reasons, the volume that I was carrying, as well as the complex cases that I would be inheriting. And also I was also concerned about the number of backlog cases that they had.
So when you were asked to go and act as the executive manager for GGI, who was the executive manager for GGI at the time?
Okay, initially the executive manager at the time was Advocate Stoffel Fourie, but there was a stage where he was no longer at GGI because he was requested to assist with legal services. And then later, from April, he was appointed as the executive manager responsible for one of the branches in provincial investigations and integration. And from there, Ms. Mutiti, who is the executive manager responsible for customer and stakeholder management, was acting in GGI as well as being the acting COO. So from April up to the end of October, it was Ms. Mutiti who was overseeing GGI as a branch. And I was told at the time that she had indicated that she wanted to go back to her position being executive manager, CSM.
So at the time, Ms. Mutiti was the acting executive manager for GGI, right?
Correct.
But she was also the acting COO, Chief Operations Officer, right?
Correct.
And she also was occupying her substantive position as the executive manager for CSM, right?
No, there was somebody who was acting at the position at the time, who was acting on her position as executive manager CSM, because she was acting on full-time basis on the position of COO.
Right, so she had two acting positions at the time. It was acting COO and acting executive manager for GGI.
Correct.
And that's when you were requested to become the acting executive manager for GGI.
Correct.
All right. So you say when you were requested by Mr. Mahlangu to act as EM GGI, as we shall call it, you were a bit apprehensive. Why were you apprehensive? You were apprehensive, I suppose you've explained it already.
Yes, I did.
But just for context, you've already described what the AJSD division did. Just for context, for a fuller context on your apprehensions. But the GGI division, you said, was dealing with more complex and technical cases, correct?
Correct.
But then you received a letter of appointment from the PP, appointing you to your acting position as EM GGI, right?
Correct.
Tsepo, can you go to PM1, which is page 3917? Yeah. Is that the letter that you got from the PP?
Correct.
So this letter says, in this letter, the PP says, it gives me pleasure to advise you that I have approved your appointment as acting EM GGI with effect from 1 November 2018 until further notice. She says, as executive manager GGI, you will oversee the GGI branch and the 3 chief investigators in GGI will report directly to you. So you are going to have 3 chief investigators in GGI reporting to you, right? As the acting executive manager. So in your portfolio as the executive manager for AJSD, which was your substantive position, how many chief investigators did you have reporting to you?
I had 2.
Right. So this meant that you would now have 5 chief investigators reporting to you, right?
Correct.
And the PP then tells you that you kindly requested to accept these responsibilities without an acting allowance, as the institution is currently facing serious budgetary constraints and can no longer afford paying acting allowances. Although you will not be paid an acting allowance, I believe that you will still benefit from performing these responsibilities from a development perspective. All other terms and conditions of your employment will remain the same. I wish you success with all additional responsibilities given to you, and I hope you will continue to contribute effectively to the achievement of the PPSA's strategic objectives. You see that?
Correct.
But you say in your affidavit that you go back to the affidavit. Paragraph 17. You say that you accepted this appointment with conditions, right?
Correct.
And in those conditions, you noted you made a handwritten note in the letter written to you by the PP that the appointment is accepted on the understanding that the leadership will support me to deal with the backlog of cases at GGI, right?
Correct.
And by leadership, you meant who?
I meant the public protector, the deputy public protector. At the time, it was Advocate Malunga, and the CEO. And at the time, it was Mr. Mashango.
And you said in that note, I'll be managing 2 positions that are demanding, and accepting the additional responsibility will not be seen as compromising my position, but instead I will be supported to ensure the success of the 2 branches, right?
Correct.
Did you discuss with the PP the specific forms of support that was necessary to make the 2 branches successful in this new arrangement?
I did not discuss with the public protector personally, but I had discussions with Mr. Mashangu because he first approached me. And as I stated, I was a bit apprehensive. So we had some discussions around this matter. And when I discussed with him, I raised some of my concerns and also what sort of support I would have expected. With regard to the public protector is ultimately accountable for all investigations, and we had regular meetings with her in dealing with both the AJSC and GGI. So I assumed at the time that the PP was aware of the support that was required. And also at the time, because there was no executive manager except for Ms. Mititi acting, PP frequently attended their own branch dashboard meetings of GGI to try and assist them with some of their backlog cases. So I assume that public protector was aware and would be aware of the support that would be required to make sure that the 2 branches are successful, and I'm also successful in carrying out my responsibilities in the 2 branches. Thank you.
Were you, in actual fact, supported by the leadership?
No, except for Advocate Malunga. When I took over, it was important for me to go through the exercise of inspection of all GGI cases just to know what I was inheriting and what I was taking over. So in the past, Advocate Malunga was responsible for assisting with backlog cases. And I had also previously worked with him in conducting inspections and assisting provinces with cases that were older than 2 years. So he was supportive. We inspected those files together during when I took over, but due to work pressures, we had to stop because I had other deadlines that were pressing, but we inspected the majority of those cases, more in particular the ones that were already older than 2 years, and we provided directives and guidance in the ones that we managed to inspect with him.
Right. So in paragraph 21 of your affidavit, you say that during the period of your suspension from October 2019 until November 2021, the two units, AJSD and GGI, were merged into a single unit. And that's the investigations unit that you are currently the executive manager of, right?
Correct. But I must also point out, I was informed by HR when I followed up that the merger of the two branches took place in January 2020. I was still on suspension at the time, but I must also point out that part of the responsibilities of the cases that fell under AJSD were transferred to the unit that is being managed by Ms. Mutiti, being complaints and stakeholder management. So a portion of the complaints that are handled by AJSD was transferred to CSM.
Okay, so I think, Ms. Mogaladi, we have sound problems. You're not coming. I think you need to either come closer or have some other solution, because you we can hear you, but you're coming through intermittently. Yeah.
Okay. I moved closer to the computer. I said it is correct that the two units were merged, and I followed up with HR. I was told that they were merged in February 2020. There was a period that I was still on suspension, and I also mentioned that it's also important to indicate that part of the cases that were being handled by AJSD, the responsibility for investigation of those cases were transferred to Complaints and Stakeholder Management Unit.
Okay, great. So you then started as acting executive manager at GGI on the 1st of November, right?
Correct.
So in paragraph 23, you set out in terms the numbers, the workload of the two branches when you took over. What do these numbers entail?
Okay, the first line is the total workload of the active cases that were being investigated by the respective units. It is cases that had already been assessed. It is cases that fell within the mandate of the jurisdiction of the public protector and were being investigated. So the first line indicates that AJSD had 749 active cases. GGI had 209. And the second line is a further breakdown of the 749. Out of those, AJSC had 108 cases that were older than a year, GGI 52, and AJSC had 25 cases that were older than 2 years, GGI had 88 that were older than a year. I think it's also important to mention that whilst it might seem that GGI had a lesser workload, these are cases that are complex. These are cases that are technical, and often you deal with a complaint that has multiple issues for investigation. And you also have to deal with voluminous evidence that takes a bit of time to deal with.
And then in paragraph 26, you start to speak about the FSCA complaint. Can you elaborate for the committee what that complaint was about?
Okay, thank you. On the 7th of April, the public protector received a complaint from the commander-in-chief of the economic freedom fighters, Mr. Malema, against the executive officer of the Financial Sector Conduct Authority. Chair, if I can correct, it's supposed to be the executive officer. It doesn't have chief executive. At the time, it was Advocate Dube TD. The main allegations in that matter related to abuse of power by Mr. TD as the EO, in that in nomination of attorneys for curatorship of the various pension funds. He favored a certain law firm that was owned by Mr. Mostert. And furthermore, and there were further allegations that there was conflict of interest, that Mr. Dube TD was not managing, and that Mr. Mostert as a curator was briefing his law firm, and he had paid his law firm fees totaling 188 million. There was also allegations that Mr. TD, in responding to a parliamentary question, misrepresented. There were also allegations that he was attending clandestine meetings with there was an attorney that was mentioned in the allegations. Furthermore, there were allegations that Mr. TD had intimidated and threatened some funds to brief and Mr. Mostert. Briefly, those were the allegations that I am taking them at high level, not going into the full details of the allegations.
So when the complaint came into the PPSA, who was it allocated to deal with?
The complaint was allocated to Mr. Isaac Matlawe, who was a senior investigator based in the private office of the public protector at the time.
And who was the executive manager responsible for dealing with that complaint at the time then?
At the time, the investigative staff in the private office of the public protector reported to Mr. Futana Tebele.
All right. And you say in paragraph 27 of your affidavit that obviously the investigation started from the private office, and there was an investigation plan that was managed by Mr. Futana Tebele, and the final report, you say, should have been submitted in November 2017, right?
Correct. We found an investigation plan on the file that indicated that according to the targets and milestones that were defined in the plan, the report should have been submitted to the public protector in November 2017.
And it wasn't submitted in November 2017, correct?
No, it was not submitted.
So was there any action taken against those who were responsible for not submitting it in November 2017?
Not to my knowledge.
Okay. So you set out the issues that were identified in the investigation plan in paragraph 27, right? which were the two issues relating to Mr. Tsiri and Mr. Mostert, correct?
Correct.
But then in paragraph 28, you start talking about what started to happen after you took over as the acting executive manager for GGI in relation to this particular investigation. And what was your involvement really after you took over as the acting executive manager for GGI in this investigation, the FSCA?
Okay. After I took over as the executive manager, I started receiving emails from the PP. Some were sent to me through the acting COO at the time being Smotiti, where the public protector was indicating that the Section 79 notice was long overdue in this matter and it must be submitted immediately. I think one of those emails that was forwarded to me was dated the 5th of November, which was the third working day since taking over the branch in question. So I followed up and made inquiries with the team, and I also had discussions with Ms. Mutiti, and she indicated that as stated, the file was initially allocated to Mr. Matlawe, but on the 4th of June 2018, the file was handed over to her, being the EMGGI at the time and the acting COO and the late Abongile Madiba and Ms. Karina van Eden as the senior investigator in GGI at the time.
So your inquiries revealed that at some point, even though the investigation had been initially allocated to Mr. Matlawe, in June it was removed from him and allocated to Ms. Motsiti's division under Mr. Abongile Madiba and Karina van Eden, right?
Correct.
Was there a handover report that you got in relation to the investigation?
No, I did not receive any handing over relating to this investigation and the others that I received. I didn't get any handing over. And I also discussed with the investigation team at the time. They said they also did not get any handover notes on the file when it was handed over to them on the 4th of June.
So you say in paragraph 31 that soon after you took over, Ms. van Eden, Karina, who was the investigator in the matter, senior investigator in the matter, started to send you an email requesting that her reporting lines to Mr. Madiba be severed and that there had been difficulties there, right? That's what you say in paragraph 31.
Correct.
Yes.
Correct. No, I wanted to indicate that I want to also correct that there it says specifically Northwest. Specifically in that memo, I want to correct it. It was in Mpumalanga and the Northern Cape where she wanted to be transferred to.
Oh, so you're making a correction. You're saying
Yes.
In about to the fifth line, Ms. van Heerden had on several occasions formally requested transfer to provinces. And as it reads now, it says specifically the Northwest. And what you want to correct, you want to say it wasn't the Northwest, actually, it was Mpumalanga or the Northern Cape. Is that right?
Yes, it's correct. And it was when I followed up and discussed with the colleagues, I was informed that there were formal requests for transfer that were submitted prior to joining, prior to my period in GGI.
Right. But you then say in paragraph 32 that soon after you took over from the GGI, the issue of the Section 79 letter in the FSCA investigation became an issue to you, came to your attention. What then happened?
I could gather from the emails that the PP had been requesting this notice from the colleagues. I think initially there was a deadline that was set for July. It was not met. And when I went through the emails and the inquiries, I noted that there was a dashboard meeting that was attended by the public protector and the team. And at the time, the notice was not ready. But thereafter, Mr. Madiba made an undertaking that he will assist in drafting the Section 79 to ensure that they meet the deadline that was imposed by the PP.
So by the time you got these communications that the Section 79 was due or overdue, had you had sufficient time at GGI to familiarize yourself with the investigation?
No, in one of those emails, it was indicated that the Section 79 notice was due on the 2nd of November. And notably, this was a day after I took over the GGI branch.
Right. You do say in paragraph 33 that you weren't given the opportunity and time to familiarize yourself with the extra work that you were taking over as EMGGI in addition to your responsibilities as EMAJSD, right?
Correct.
And you say you found yourself in a situation where on your third working day already in GGI, you were receiving emails about the submission of the Section 79 notice and that you were not familiar with the matter at all, right?
Correct.
Did you express this challenge to the leadership whom you expected to support you?
I expressed my challenges and frustration to the CEO, Mr. Mahlangu. I pointed out that I had not also received the handing report. I was given a copy of the handing over report that was compiled by Advocate Fourie when he left for the Eastern Cape and for provincial investigations at the end of April. It was a high-level report that was not going into the details of each and every investigation. It just indicated the status of the matters at high level. So that's what I was provided. Mr. Mahlangu also indicated that he cannot really help much as most of the notices and the reports were long overdue even before I took over and PP wanted them.
Yeah. So you've already said in paragraph 32 of the affidavit that stop the ship. Go down.
Don't whisper. Get to the mic.
Sorry. Yes, there. You already said in paragraph 32 of the affidavit that the Section 79 letter should have been submitted on the 2nd of November 2018. Do you see that?
Yes.
Go down. 35. Was it submitted on that date?
No, it was not submitted.
So what happened?
I was later informed that on the 2nd of November, the late Mr. Madiba submitted a memorandum to the public protector. The memorandum was submitted.
Wait. And that's the one that you referred to in that paragraph as it's marked PM2, right?
Correct.
Okay, can you just give us a minute so we can go there? So can you go to PM2? It's page 3919. Is that the memorandum that you are referring to?
Can you scroll down a bit? Yes.
Yes.
Is this correct?
Okay. Scroll down, Tsepo. What was the purpose of this memorandum by Mr. Madiba?
Mr. Madiba states in paragraph 1.1 of that memorandum that the purpose of the memorandum was
We didn't hear that. You didn't hear that.
Okay, let me. Mr. Madiba provides in paragraph 1.1 that the purpose of the memorandum is to provide a report on the reasons why the Section 79 notices on the investigations against Mr. Fikile Mbalula and the FSB were not transmitted to the public protector for signature as expected, as per resolution of the meeting held between the public protector and held between the Office of the Public Protector on Monday, 22nd of October.
So, and then in paragraph 2, Mr. Madiba provides a background to the matter. In paragraph 2.2, he then says that I reworked the notices in preparation for submission at the 25 October 2018 as required. And he says the notices were ready for submission, albeit not in a satisfactory state as according to my standards. And those that are expected from the office, in particular an official occupying a senior position of a chief investigator. And he says, I'm still not satisfied with the notices and I was going to submit them just because I was required to do so. And he says he attached here with copies of the notices for the PP's reference marked A and B respectively. You see that?
Yes, I can see that.
Yeah. And then in paragraph 2.3, he says the investigators who were responsible for the investigations are Ms. Chantal Naidu in respect of the Fikile Mbalula investigation and Karina van Eerden in respect of FSB. You see that?
You can see that.
Can you read what he says in paragraph 2.4, please?
Okay, in paragraph 2.2, Mr. Madiba said, with respect, the quality of the work done by these investigators left much to be desired. Hence, I had to take it upon myself to assist them in providing qualitative work that would not embarrass the public protector in the end. It would further be very irresponsible for me to submit substandard work to the public protector and expect her to append her signature to same.
And he says in the first sentence of 2.5, the sensitivity and complexity of the two matters require one to fully apply his mind on same if he wants to produce quality work. And then in paragraph 2.7, Mr. Madiba then set out his challenges and what other investigations he was involved in. And he said that other than the above, there's been a number of other investigations that I've been actively involved, particularly in my capacity as the chief investigator, to ensure that GGI maintains the standards of quality that we were taught by Advocate Stoffel Fourie. And he goes on then in the sub-paragraphs there to list what those are, including him rendering assistance to the Zondo Commission and so on and so on. And in paragraph 2.8, it says that the above is just an example of the sensitive and complex matters that I'm involved in, which require one to fully apply his mind and experience. And experience has shown me that he's addressing the PP, you do not let work from investigators to leave your desk to the PP without applying your mind fully as that would embarrass you. And then paragraph 3, can you read he makes a motivation in paragraph 3. Can you read that, please, Ms. Mogaladi?
He states that due to the above reasons, it will be appreciated if the public protector could consider affording me an extension until Friday, the 9th of November, 2018, to allow me to apply my mind fully on the two matters and submit these notices as I am submitting them, despite the fact that I am not satisfied with them in their present state. Whilst I am applying my mind on the two matters, I request that I be allowed to only concentrate on them and nothing else, so that my attention is not diverted to other investigations.
And then, of course, he says in 3.2, in the event that the public protector is not satisfied with how I handle the matter, she's at liberty to decide that they be reallocated to other capable investigators in the office. And in paragraph 4, he makes a recommendation, and his recommendation is that the PP consider and approve granting him an extension until Friday, the 9th of the 9th of November, 2018, to submit finalized section 7.9 notices for both matters and issue directives that, whilst concentrating on those two notices, he not be diverted to other tasks. You see that?
Yes, I can see that.
Go down, Tsepo. As far as you're aware, is that the signature of Mr. Madiba?
Yes.
Go down, Tsepo. And then he makes a recommendation really for his. So that's the PP's signature there, right? This memo was signed by the PP, correct? Good.
Correct.
Right. And is that her handwritten note on the right-hand side next to her signature, as far as you're aware?
Yeah, correct.
And can you read what the PP's response is to this memo from Mr. Madiba, just the first paragraph of that? Yeah?
Okay. The first paragraph states, Madiba, your explanation is not accepted and feel undermined by just indicating that if not satisfied, must reallocate. That means there must be consequences against you, same to those I took the FSB matter from.
Thanks. What does the acronym or the letters ACOO stand for?
Acting COO.
And that was Ms. Ntoriseng Motsitsi at the time, right?
Yes, on the 2nd of November, 2018, it was Ms. Motsitsi.
What instructions does she issue to the ACOO in her handwritten note?
Okay, on there, the public protector says, acting COO, can I have the investigator section 7.9 of Mbalula to sign? And then in brackets, PP says, do not agree with the revised version by Madiba. And she wanted it today. And then in brackets, there was an annexure C. I'm taking it that annexure C is what Madiba had annexed to him, to his memo to the public protector. Can I continue to read?
Yes.
Okay, the public protector in that handwritten note further said, Madiba to be issued with a verbal warning and Ms. Sekele for not meeting the target set to submit the two section 7.9s. Can I have the reworked section 7.9 of FSB by end of business tomorrow?
Right.
And the handwritten notice is stated the 7th of November, 2018.
Now, Ms. Sekela wasn't mentioned at all by Mr. Madiba in this memo, right?
Correct.
And yet the PP says that she must be given a written warning for not meeting the target to submit the two section 7.9s, right?
The PP said she must be given a verbal warning.
A verbal warning, yeah. So do you know what connection Ms. Sekele had to these matters to warrant a verbal warning in this manner?
It is not clear from the memo, but I think her name was brought into this memo because at the time, Ms. Chantel was reporting to Ms. Sikele. But however, as the memorandum states, because she was previously working with Madiba, she was reporting to Madiba on the Balula investigation. So it is not clear as to why the public protector brought her on this, because in the memorandum, Madiba acknowledges that he is working on the notice with Chantel.
Okay. Going back to your affidavit, go back to the affidavit, Seppo, paragraph 40. Now, returning to the affidavit, you say that Mr. Madiba then finished drafting the Section 79 notice on the 21st of November, 2018, right?
Correct.
And then what happened after that?
Mr. Madiba emailed the draft notice to me on the 21st of November. But in the email that submitted, he had certain reservations about the investigation because he felt that some of the issues we might have investigated issues that were already dealt with in court matters. So because this notice was long overdue and there had already been decision that action should be taken against us for not submitting the notice, I forwarded that notice to the PP on the 22nd of November in the morning at 4:33. And in my email, I indicated to the public protector that Mr. Madiba submitted the draft with reservations and was concerned that we might be challenged in court. And I also indicated that I have just taken over in GGI and need to review the files and the court judgment before I can express an opinion and request an opportunity to conduct legal services on the implications, because there were legal issues that were consistently being raised by the parties in the matter.
All right.
And I was aware that legal services had previously attended meetings with the public protector based on the record.
And you say you then forwarded it to the PP by means of the email that you say is PM2A, right?
Correct.
I think let's go there to the email. It's 3924. So your PM2A starts at 3924, but for the purposes of the committee, of course, when there's an email trail, these things, in order to understand the whole thing, you have to start earlier in the email trail. And so that is what we are going to do. We'll go to the beginning of your email trail, which starts on 3927, right?
Correct.
Right. This is where you say you sent it to the PP, right? Can you just read what you said there?
Okay, I said, dear public protector. Okay, I just want to move. Dear public protector, attached here too is the draft FSB section letter. Mr. Madiba submitted the draft with reservations. He is of the view that we may be challenged for investigating issues decided in court. I have just taken over GGI and still need to review the files and the court judgment before I can express an opinion on this matter. I hereby request that we be given an opportunity to meet with Mr. Namasisi and address Mr. Madiba's concerns before the Section 7(9) letter is signed. I have also attached copies of the 2 judgments that Mr. Madiba is concerned about. Regards.
And you copied Mr. Nemasisi on this email, correct?
Correct.
And the PP responded, right? She responded on 3926 at the bottom. That's about there. Right?
The PP did not respond to me directly on that particular email.
So what you're saying is she responded, but you were not included in the response, right?
Correct.
She responded she wrote rather to Mr. Nemasisi, correct?
Correct.
And what she said is, in response to your concern, Nemasisi, can you check the concerns they have on the court judgment? No court judgment was investigated, but it was referred to because it was a matter pending between the parties, in brackets, attorneys of the complainant and EFF were told we cannot intervene on those, close brackets. You were part of the meeting. Advocate Busisiwe Mkhwebane, is that the response you're referring to?
Correct.
All right. Go up, Tsepo. And then Nemasisi, Mr. Nemasisi appears to have responded on the 27th of November, and you were not copied on that response, right?
Correct.
And he gave what appears to be a lengthy response, which ends, go down, Tsepo. Which ends there. Do you want to read the last paragraph, please?
Considering a number of issues which needs to be investigated, the complexity of the issues and urgency of the matter, we propose that PP establish a special investigation team to focus on this investigation to ensure that all complaints and all the applicable law is properly ventilated. This is because the implicated parties, that is Mr. Moss, that is Mostert, are known to be a litigant.
Do you know if the PP took this advice? This is the last paragraph of that advice, by the way. It was a lengthy advice, but do you know if the PP considered that advice that was sent to her on the 27th of November?
I am not aware that this advice was taken because I was not copied in the communication and I only learned this through interaction with Mr. Nemasisi. So as far as I know, this was not implemented, this last part.
So your evidence is the following, that Mr. Madiba submitted the Section 7(9) to you on the 22nd and you forwarded it to the PP on the 22nd, right? Under reservation, you stated to her that Mr. Madiba has these reservations and so on. Is that correct?
Correct.
And you told the PP when you submitted it to her that you haven't had time to familiarize yourself with everything and you would like to consult with legal regarding certain matters, right?
Correct.
And then the PP, of course, asked legal on the 24th around the issues that you had raised, correct?
Correct.
But you do say in paragraph 45 that you were not copied into these emails between the PP and Mr. Nemasisi. And so you were not aware of those interactions, right?
Correct.
And your evidence is in your affidavit that the PP proceeded to sign the Section 79 notice on the 26th of November, right?
Correct.
But you got the advice from Mr. Namasisi only on the 27th of November. And that is why you say in paragraph 45 that by that time, his inputs were, the notice was a fait accompli. Is that correct?
Correct.
And then what happened after that?
The Section 79 notice that was signed, it was disseminated to the parties. And following that, there was exchange of correspondence between the parties, the FSCA, and one of the implicated parties, Mr. Mostert. There was the exchange of correspondence, and then the main event that unfolded around this matter was on the 29th of January. We were served by, the public protector was served with an urgent application for an urgent interdict by one of the implicated parties, Mr. Mostert, whereby he sought an order interdicting and restraining the public protector, the complainant, and one of the parties, Mr. Nash, from publishing, causing to be published, or in any other manner disseminating or causing to be disseminated to any person or to the public, whether the media or on social media platforms or otherwise, the Section 79 notice that was issued by the public protector on the 26th of November, pending the final determination of an action or application by the North Gauteng High Court. By an application, he had filed the application for an urgent interdict. So he was saying pending the determination and decision by the North Gauteng High Court, the notice that was already circulated should not be disseminated to any further by any of the parties, including the PP. And he indicated that the action was to be instituted within 30 court days from the date of the order. And further in the application, as mentioned, his main grounds was that the PP does not have the power to investigate the subject matter of the complaint. So he wanted the court to review and set aside the decision of the public protector to investigate the complaint. He also wanted the court to review and set aside the PP Section 79 notice dated the 26th of November 2018, and that the PP be further interdicted and restrained from further investigating the complaint. And finally, interdicting and published, and PP be interdicted from publishing the findings in respect of the complaint.
Yeah. So in your affidavit from about paragraph 51 onwards, you speak of new developments, though, that occurred quite apart from this urgent application that had an impact on the issuing of the final report, right?
Correct.
And these new developments, as you detail them, also include the email trail that appears as Annexure PM3 to your affidavit, right? And I'll take
Correct.
you there. Is that right? Okay. Now, this email trail, as email trails go, it starts from, it's PM3. PM3, SEPO starts from 3929. But it ends at 3932. But as email trails go, you have to start at the bottom in order to get to the top to understand the chronology. And so we'll start at 3932. Are you with me, Ms. Mogaladi?
Yes, I'm with you.
Yeah. And so what is it that was happening there on the 2nd of March, 2019?
Okay, I think maybe just to put matters into proper perspective, I think I mentioned that there was an application for interdict. It was initially set down for the 12th of February, and it was later postponed to the 19th of February. So what this entailed was that until such time that there was a court decision, there was very little that we could do in terms of further disseminating the Section 7.9 or any findings on the intended findings on the investigation. So, but I think internally we still had some of the discussions as a team regarding the way forward. And as I've alluded to in my affidavit, one of the discussions related to the fact that the Section 7.9 was not originally issued to the board, and we were discussing what we still needed to do as a team to close some of the gaps. But it must be borne in mind that those discussions were happening whilst there was that pending litigation between the parties, and by agreement, Mr. Mostert it was agreed that he can make his submissions to the public protector on the Section 7.9 notice, and the due date for submission was the 1st of March. So in between that, Mr. Abongile Madiba received an email from Ian Levitt attorneys, who were the attorneys that were representing the complainants in this matter, whereby they had attached a letter. In the letter, basically, it indicated their intention to submit additional documents. So the email on the screen.
Is that the email that we are looking at now?
Yes, it is correct. There is the email on the screen.
And that's the email from the complainant's attorneys of record, right?
Correct.
So we'll go up to 3931 to follow the sequence. And then Mr. Madiba, is that his response, notifying you all that he had received this communication?
Correct.
All right. Go up. 3930. We can't see the numbers. I can't. Actually, it's still on 3931, Sepo. 3931? Yeah. So this email was from you. It appears really at the bottom of 3930. Yeah. It's from Ponatshego Mogaladi, 3930. Yeah. Yes, that email. You recognize that email, right, Ms. Mogaladi?
Correct.
Yeah. And in that email, you were writing to Dibas is Mr. Madiba, I assume, right?
Yes, Dibas is Mr. Madiba. That's how we called him in the office. We called him Dibas.
Yes. And it was sent on the 26th of March. Yeah. But go down. And you're saying to him, you've discussed the finalization of the FSB report with the PP yesterday on the 25th of March. And you alerted the BP to the letter from the attorneys of the complainants. And the complainants was Mr. Malema from the EFF wherein they requested us not to finalize the report before they submit additional evidence. And then you carry on, you say to Mr. Madiba, the PP requests you to clarify the additional evidence that was requested from the attorneys. According to the PP, all the evidence was submitted to Mr. Matlawe. You see that?
Correct.
Yeah. Can you move up to 3930 for us to see the PP's response, please? Yes. So the PP's response, do you see that? And you were copied on it, right?
Correct.
And she says, she says to Mr. Madiba, what information you requested from attorneys which is not in the files and records which you were given. You see that?
Correct.
Go up.
Yes, I can see that.
Yeah. And Mr. Madiba then responded and he says, there's no particular information. This lady attorney was just pestering to see the investigator regarding the matter. We met and discussed the same in general together with issues identified for investigation. She offered to assist on same should a need arise, an offer which I welcomed. That was the end of it, right? You see that? And she says, dear ma'am, 3929. Can you explain to the committee what that email was about? It's from you and it's to the PP on the 26th of March in the evening at 26 minutes past 10 p.m.
Okay. This email was a follow-up to the earlier discussion that I had with the public protector.
We can't hear you. We can't hear you.
Okay. This email was a follow-up to the earlier discussion that I had with the public protector regarding finalization of this investigation. And in the email, I had indicated to the public protector that there were files that were received from the EFF attorneys on the 25th of March. So the PP indicated that we should check what the contents of that. So here in the email, I was saying I have checked with Karina. Karina is Ms. Van Eden, who was the investigator. And she indicated that the attorneys of the EFF delivered 5 Agliva files of evidence yesterday after hours. The difficulty for us is we do not have sufficient time to review the evidence that was delivered yesterday. And I was asking the PP, can we focus on finalizing the report based on the old evidence, as we do not have sufficient time to review the evidence in the file submitted yesterday.
So what you were proposing, because you had received 5 extra Liber Arch files after hours on the 25th, you were asking the PP whether you could finalize the report based on the evidence you already had, right?
Yes, correct, because the discussion from the PP and the directive that we had received through the COO at the time was that there was a media briefing on the 28th, and this report was supposed to be released during the media briefing on the 28th. So it was 2 days. The 26th was 2 days before the media briefing. So we had to finalize the report.
Okay. Can you go up, Tsepo? All right. And the PP's response was to say, at 26 minutes past 11 on the same evening, I said to CEO, the report must be finalized. You need to peruse the documents submitted and compare with the evidence we had already. Why was I not answered as to what additional information Madiba wanted from the attorneys of EFF so I can advise? He did not give specific answer, which I'm still awaiting. You see that?
Yes, I can see that.
And any comment to that?
My comment to this is that, look, the first paragraph, what it meant is that we did not have any option. The report had to be finalized and be ready for the media briefing of the 28th. Secondly, on the second paragraph, the PP was saying that Madiba had not responded, but according to the trail of email, Madiba responded to the PP and explained the information that was received in the earlier email that was sent around 10 in the morning.
Okay. So Ms. Mogaladi, I suspect the chair is about to order a tea break, but chair, this is an opportune time for her to end this leg of her story. So what happened after that then? You got the instruction from the PP at 26 minutes past 11 p.m. on the 26th of March that the report has to go out. And as you say, the media briefing was on the 28th of March. What happened?
We had no choice. We had to start working. We worked through the day, the 27th. Being the investigator, in particular Ms. Van Eden, I notified, she was already aware that the report had to be drafted. She started drafting and finalized it in the afternoon of the 27th. And then we worked until around early hours just to make sure that the report is complete and ready for the 28th. And it was submitted to the COO at the time. But due to the pressure of time that we had, the report, we had to work together as a team just to make sure that as we are progressing and working on one page, the next person starts reviewing that page because we did not have a lot of time to review it. But at the time, there were processes that were in place in the office. The report did not go through some of those quality assurance structures and processes that we had in the office because we only had a day to finalize the report.
And it was you and who? You mentioned Ms. Sekele in paragraph 59 of your affidavit, but it was you, Ms. Sekele, and who were working on the report on that day?
Yes, it was the investigator was the main person who was working on the report. Ms. Sekele was assisting as the chief investigator, myself as the EM, and later in the evening we were joined by Ms. Basane Baloi, who was the COO at the time.
And so you say you worked during the day on the 27th and into the early hours of the 28th, you say?
Yes, correct.
And when was the report handed over to the PP for her signature and the media briefing?
I think Ms. Baloi, from our side, when we finished during the early hours, we submitted it to Ms. Baloi.
On the 28th?
Yes, on the early hours of the 28th, and she submitted to the PP in the morning of the 28th.
And it was issued in that media briefing on the 28th,
yes,
right?
Yes, it was issued on the same day.
Okay.
Thank you. Thank you, Ms. Mogaladi. Alfred Mayosi will take a break. We'll be back at 11:45.
Recording stopped.
That time stands. If somebody eats into that, not my business. Thank you. Honorable Jane Mananiso, are you there? Honorable Jane Mananiso? I'm recognizing you because you would have worked on your picture. Thank you very much, Honorable Jane Mananiso. That was quite an efficient time. Yes, it's called facelift. Thank you, much appreciated. Ms. Mogaladi.
Chairperson?
Yes, can you hear me?
Yes, I can hear you, Chairperson.
I can see you now properly and we can hear you much, much better.
Thank you, Chairperson. I requested our IT department to assist.
I don't know who did the trick, but let's hope it's working now.
Thank you.
Thank you. I now hand over to Advocate Mayosi.
Recording in progress.
Are you back, Ms. Mogaladi? Thank you. So we move on to where we left off. You had said how we left off at where you were describing for the committee how the report was written and finalized following the PP's instruction of the 26th of March at 26 minutes past 11, that the report simply has to be done. So where we are in your affidavit is page 3894. And we'll deal briefly with Ms. Sekele, the section that says Ms. Sekele and the FSCA investigation. For her part then, she joined the PPSA in April 1999 as a senior investigator, right?
Correct.
And in April 2018, she was transferred to the GGI investigation branch as chief investigator, correct?
Correct.
And you do say in paragraph 62 that after Ms. Karina van Eerden indicated that she needed to sever her reporting lines from Mr. Madiba. Mr. Madiba was then replaced by Ms. Sekele as the chief investigator to whom Ms. van Eerden reported, right?
Correct.
And Ms. Sekele, in terms of paragraph 64 of your affidavit, she wasn't really involved in the FSCA investigation, and she became involved at an advanced stage of the investigation only from about December 2018. And it was a complex matter, right?
Correct.
Thanks. So we move on to the next section of your affidavit, which is the FSCA and RABI litigation. Tsepo, and that's the notice of motion in the FSCA matter is in bundle A, page 1988. I don't know what item it is. You've got it? Yeah. So please just tell the committee briefly what this litigation was about. So the report is then issued on the 28th of March in 2019, and then litigation ensues. Can you tell the committee what that was about?
Okay. Following the issuing of the report by the public protector, the FSCA filed the notice of motion in the North Gauteng High Court requesting the court to review and set aside the report of the public protector. It was report number 46 of 2018/19. The prayer was that the report should be reviewed and set aside and declared constitutionally invalid for lack of jurisdiction. That was the first prayer. In the alternatives, the prayer was that the conclusions and findings in paragraph 5.138, 5.139, and 5.222, 5.328, 5.329, 5.474, and 6.1 to 6.4 of the report, and the summary thereof in paragraph X and A to D of the report are reviewed and set aside and declared invalid, unlawful, and unconstitutional. And that
Did the PP defend the review?
Following the process in the office is that normally if there is a litigation, there would be a litigation strategy by legal services. The firm of attorneys was VZLR attorneys was appointed, and in turn they briefed Advocate Henny Smith, and the junior counsel was Advocate Chabalala. The PP defended the matter, but however, there was a part of the report where the PP decided that particularly the prayer 2, the PP considered and agreed that the report can be reviewed and set aside on the basis of the alternative. But on the first part, the PP defended the issue relating to the lack of jurisdiction.
So one of the issues that arose in the matter, in the litigation, was an incomplete Rule 53 record, right?
Correct.
What role did you play in compiling the Rule 53 record?
The Rule 53, initially, legal services requested the investigator who was dealing with this matter to compile the record, and the record as compiled by the investigator was filed. During consultation, as we were preparing to defend the matter, it was brought to my attention. It was around August when the first part of the Rule 53 record was filed. It was brought to my attention that the record was missing around the beginning of August during our first consultation. So that's when I became involved, as we were requested to find some of the information that was not part of the Rule 53 record. So I became involved after the first part was filed, and the applicant had filed a supplementary affidavit indicating that the record was incomplete. So that's when I became involved.
Right. So judgment was handed down in the matter on the 9th of October, 2020, right? Tsepo, please go back to the affidavit on page 3897. Yeah. That's where we are now. Go down to paragraph 71, sorry. So you say in your affidavit, and I'm just wanting to move on from this, the judgment was handed down on the 9th of October 2020. The report was reviewed and set aside and declared constitutionally invalid for lack of jurisdiction, correct?
Correct.
And the PP was ordered to pay the costs of the application, right?
Correct.
Right. So moving on to the next section of your affidavit, which is the disciplinary proceedings against you and Ms. Segele. So, Mr. Mahlangu then in October 2019 initiated disciplinary proceedings or steps against you, Ms. Segele, and Mr. Madiba, right?
Correct.
Can you tell the committee briefly how you were notified of the initiation of these proceedings?
I received a letter from Mr. Mahlangu. It was dated the 10th of October, where he was requesting me to make representations on the intended disciplinary action against me. The initial letter of the 10th, it was just focusing on the FSCA investigation. The letter also requested me to make representations on the intended disciplinary action as required in the policy. But however, specific in the PPSA disciplinary policy is that if the employer intends to suspend, you should be given an opportunity to also make representations on the intended suspension. In my letter, I was not given that opportunity. The letter did not refer to any intended suspension. So I responded on the intended disciplinary action because I was not aware that there was an intention to suspend me.
But as a result, of your representation.
Okay.
Sorry, Ms. Mogaladi, do you wanted to say something?
Yes, I wanted to indicate that I responded to the CEO on the 22nd. The initial date was the 18th, but I requested extension until the 22nd. And it was granted, and I responded to the CEO on the 22nd of October.
And then what happened on the 22nd of October?
2 hours after submitting the representations on why disciplinary action should be taken, why disciplinary action should not be taken against me, I received a letter. It was personally brought to my office by Mr. Gumbi Jelela, the HR manager, suspending me from the office with immediate effect. It was received 2 hours after I had submitted my representations. I had to leave with immediate effect. I had to leave everything, the employer's assets and everything. And he indicated that he was told that I had to leave with immediate effect.
Right. The suspension letter that you got from Mr. Mahlangu is the one on PM4, page 3934. Tsepo, can you go there, please?
Can you scroll down a bit so that I can see? I can only see the logo. Scroll down a bit.
Scroll down a bit.
Yes, that is the letter.
Okay, where he says he refers to your letter, to his letter dated the 10th of October, where he invited you to make representations, right?
Correct.
Go down, Tsepo. And he acknowledges receipt of your written representations dated the 22nd of October, and he confirms that he thoroughly considered them and applied himself to them in making a decision as to whether or not the PPSA should institute disciplinary proceedings against you, right?
Correct.
And in paragraph 3, he once again reiterates his view that the issues at hand amount to serious allegations of gross misconduct against you, and they are viewed by the organization in extremely serious light, and the PPSA therefore intends instituting disciplinary proceedings against you, right?
Correct.
So he says in paragraph 4, further having regard to the gravity of the matter, the organization has taken a decision to place you on a precautionary suspension on full pay for a period of not more than 60 days from the date on which you acknowledge receipt of this letter, pending the final determination of your conduct by way of a disciplinary process to be instituted against you, right?
Correct.
on which date did you receive this letter? When did you acknowledge receipt of this letter? It's dated the 22nd of October.
I received on the same day, the 22nd of October.
And ultimately, how long was your period of suspension?
I was on suspension for a year and 10 months during the disciplinary hearing and a further 3 months after the sanction imposed by the chairperson. So overall, I was on suspension for 2 years and a month.
Mr. Kelly also received a similar suspension letter on the same day, correct?
Correct.
Was this the same day Ms. Basani Baloyi was suspended or not?
I think Ms. Baloyi was suspended on the 21st. So this was a day after Ms. Baloyi's suspension.
Okay. Your evidence is that Mr. Madiba was also suspended, right?
Yes, correct. He was suspended on the same day.
What happened to his disciplinary process?
Chairperson.
Just a pause, Advocate Mayosi. Advocate Mpofu.
Yes, Chair, yes, I just wanted to check with Advocate Mayosi whether the witness is making a mistake, or is that what the evidence is about Ms. Baloyi's suspension?
Sorry. So I think the witness said she thinks that Ms. Baloyi was suspended the day before.
Yes, but Ms. Baloyi was never suspended any day before or after.
Correct. Yes. So you are aware, of course, Ms. Mogaladi, that Ms. Baloyi was on a probation, as the employer says, and then her permanent employment was not confirmed, right?
Correct.
She was told that her permanent employment was not confirmed then on the 21st of October.
Correct.
She had to leave the premises on that day. Is that right?
Yes, it's correct. So let me correct myself and say it was the day before she left the office.
Chairperson. Chair.
Just pause, Ms. Mogaladi. I don't see your hand, Honorable Mahlaule.
My apologies, Chair. I just want to raise that I'm not sure whether it's the witness surroundings or elsewhere, but there is somebody who is speaking on the side and disturbing the processes. It looks like it's another meeting. Somebody logged on 2 meetings. Can we sort that one?
Okay. Thank you for that. We'll make sure that whatever gadgets, whether TV, if Ms. Mogaladi has, can switch them off. But
Sure.
she would not be in control of noise around her surrounding. So we'll check that so that she can attend to it.
Chair.
Honorable Ngola.
No, Chair, I want to register that there is generally an echo. Even when Honorable Mahlaule was addressing, there was an echo at his background. So maybe it's an ICT kind of an arrangement through Zoom. So if they can check that as well. Thank you.
Yes, that's that. We have no echo from you. So it would not be an IT problem. We'll watch that as they respond so that we also ask IT to fix that if there is such an echo. Are you ready, Ms. Mogaladi?
Yes, Chairperson.
Thank you. That seems to be proper.
Thank you.
Over to you, Advocate Mayosi.
Thank you, Ms. Mogaladi and members. Sorry, I think I disturbed you when I asked you about Ms. Basani Baloyi, and you were describing or telling the committee about how the process went for Mr. Madiba. I had asked you, you had said earlier in your evidence that Mr. Madiba was also suspended. And my question to you was, what happened to his disciplinary process? Can you tell the committee about that, please?
Okay. Okay. The disciplinary process the matter was set down together for the three of us. Initially, the matter was set down for December. The hearing didn't proceed. Then we received the revised charges for the three of us, and the matter was set down for March. But however, due to the lockdown, the case could not proceed until July, and the matter was set down for all three of us on the 6th of July. But at the time of the set down, Mr. Madiba was hospitalized. Mr. Madiba was sickly. He had stroke in December 2017, so we were struggling with his health. So at the time, he was hospitalized. So initially, our legal representatives requested postponement of the matter, but the employer was not amenable to postponement. After discussions, Mr. Madiba's matter was separated from our case. The hearing proceeded against me and Mr. Kele, and a separate chairperson was appointed for Mr. Madiba. And in our case, we continued with Advocate Kuboni as the chairperson.
And can you tell the committee what the outcome of Mr. Madiba's process was?
The outcome of Mr. Madiba's case, he was dismissed around June 2021. And he later passed on about a month after he was dismissed in July 2021.
Okay. And then in the next section of your affidavit, you of course deal with the charges against you and Ms. Sekele. How many charges did you face?
I faced 6 charges.
And the charges against you are the charges detailed in charges 1 to 4 were for gross negligence or recklessness in the performance of your duties and or failure to effectively manage subordinates in relation to the FSCA matter, right?
Correct.
And charge 5 was for unprofessional conduct and or conduct unbecoming of an executive manager in the office of the PP, right?
Correct.
And charge 6 was for gross reckless dereliction of duty, alternatively gross misconduct, right?
Correct.
Can you just detail for the committee, when we go back to charges 1 to 4, it had various sub-charges and various allegations that were made in support of that charge. What were those allegations made in support of that charge?
Okay, as a start, it should be noted that charge 1 to 5 arose from the FSCA investigation, and the 6th charge is the one that arose from a different matter, being the Rabi matter. So with regard to the FSCA, the first sub-charge, it was alleged that I had taken no action, meaning disciplinary action against Mr. Madiba for abandoning his role as the chief investigator, and or his failure to perform a proper and diligent handover of files, information received from the FSCA. Maybe just to put this into proper perspective, Mr. Madiba was the chief investigator. Earlier on, I indicated that the files were handed over to him and Ms. Van Eerden, and when the target was not met, he made an undertaking that he will step in, assist and draft the Section 79 letter. So the charge was basically that he did not hand over the files properly back to Ms. Van Eerden. So I should have charged him for that.
But Madiba, there were two further components to charges 1 to 4, which related to the Section 79 notice and to the Rule 53 record, correct?
Yes, correct. Subcharge 2 stated that in performing my supervisory role, I ought to have been aware that the Section 79 that was signed by the PP on the 26th of November 2018 was defective for various reasons. The various reasons were stated out in detail in the charges. But they centered around the fact that the evidence was not properly ventilated in the draft Section 79. The issues in that particular 79 related to decisions of court. The case was older than 2 years, and I did not articulate the reasons that the public protector took into consideration in deciding to investigate the matter. There was also a contention from the FSC that the EFF was not the true complainant in this matter, but rather that Mr. Simon Nash was the true complainant. So the charges related to the fact that I did not disclose in the Section 79 that Mr. Nash was the true complainant and not the EFF. So basically, those were some of the issues, and also it related to the fact that some of the evidence was not included in the particular Section 79 notice. Subcharge 3 stated that in performing my supervisory role, I failed or refused to ensure that the defects in the Section 79 notice were not repeated in the final report that was signed by the PP at the end of March. And it was further said that as a result of this, the FSCA report suffered defects and rendered it indefensible in the review application instituted by the FSCA. Subcharge 4 related to the fact that when, yes, the Rule 53 record, that I failed to file a comprehensive record. Can you scroll down? Charge 5.
The allegations in support of Charge 5 related to the manner in which it was alleged you conducted yourself during consultations with counsel in the litigation, right?
Correct, yes. The allegations was that I expressed and or supported the view that I had my own concerns and doubts as to the veracity of the complaint and the FSCA report. Further, that I expressed or made comments or conveyed an attitude to counsel that I had no faith and confidence in the investigation that culminated in the FSCA report. But basically, it related to the discussions that we had during consultation with counsel during the litigation of the matter.
And Charge 6 was for gross reckless dereliction of duty, alternative gross misconduct, and this arose from the Rabi matter. Can you tell the committee very briefly what the Rabi matter was about?
Okay, the Rabi matter was a complaint that was received from Mr. Rabi by the public protector in 2011. It was a complaint lodged against ESCOM. The complaint at the time was handled by the former colleague, being the unit that was managed by Advocate Fourie. It was closed by closing report signed by Advocate Fourie in 2014. Mr. Rabi, around 2018, took that report on judicial review. The approach and the decision by legal services was that the office should not defend the matter because Mr. Rabi did not have good prospects of success. It was based on arguments such as, for instance, the application for review was out of time, and also substantively on the issues that it was raising, it was indicated that he did not have good prospects. So the application for review was not defended. In his prayers, amongst others, Mr. Rabi requested the court to review and set aside the closing report signed by Advocate Fourie and to direct the public protector to re-investigate the complaint, and that the investigation, the report should be completed within 3 months. I think to break it down, it said the investigation should be completed in 2 months and the report issued on the 3rd month. So the matter arose from that. Following receipt of the court order, because the court ruled in favor of Mr. Rabi, it upheld his request, the matter was referred back, and we got an order which directed the public protector to investigate and conclude the matter within 3 months. And there was a cost order. So legal, when they got the court order, recommended that the matter should be allocated to GGI. Specifically, the recommendation was that to ensure that we comply with the court order, there should be a preliminary investigation that is conducted and a report issued within that particular 3 months. And there was also a recommendation that said that the investigation should be allocated to a chief investigator. The submission went through different people. It was directed at the public protector. I think legal and the CEO recommended, but the late Mr. Nyambe was a chief of staff. He raised concern, and actually his HR comment handwritten on the submission was that he doesn't agree with the submission from legal because he felt that legal was cutting corners in the matter because the case is complex and cannot be concluded in 3 months. It went to the public protector. The public protector signed the submission but did not per se indicate whether she was approving the recommendation from legal services. Instead, the public protector made a handwritten comment where he said, CEO, can you see the challenges relating to not defending these court matters? And then the directive was that the CEO should engage with the investigation team. So my charges around this matter, we couldn't finalize that investigation and conclude it in 3 months because firstly, the advice that was provided by legal services, it was problematic because it is clear from the public protector and the rules that you conduct a preliminary investigation with a view to determine the merits of the complaint. And then there are various steps that you take once you have conducted the preliminary investigation. One of them would be either you decide to close the matter or you conduct a full investigation. So it was problematic in the sense that Mr. Rabi in his papers was alleging that the initial complaint was not properly investigated. I think he used the terminology whitewash, that it was a whitewash because the matter was closed on the basis that he had entered into a settlement agreement with Eskom. So there was never a proper and a full investigation. And also taking into consideration the various timelines for conducting investigation, it was not possible to investigate the matter of such complexity within the timelines as alluded to. And so the charges related firstly to the fact that the investigation was not completed and also relating to the fact that the file was not allocated to a chief investigator but was rather allocated to a senior investigator to investigate. And there was also something Dora said that as a result of that, the public protector was interdicted and was held in contempt of the court order. But what happened is that there were other parties that came on board during that litigation because as soon as we started raising allegations against Eskom and the other implicated parties, then they realized that the court order was obtained without serving them as the interested parties. Hence, initially, they had requested that we should give them an opportunity to take the decision to reinvestigate the matter on review. It was not agreed on, and they sought an interdicting the public protector from proceeding with the investigation. So that is basically what happened in this whole Rabbi matter. So my charge and Ms. Sekele related to that particular investigation. One, that I did not assign the matter to a chief investigator, and secondly, that we could not complete the investigation within 3 months.
Okay.
And I must also point out that, okay.
Continue. Finish up.
Okay, I was saying I must also mention that the nature of the issues raised by Mr. Rabi fall within what we term conduct failure issues, and the turnaround time that has been set for concluding such investigations is 24 months, and hence I was saying the strategy that was proposed by legal services, it was difficult, it was not possible, it was incapable of being achieved. So the charges stemmed from this particular matter.
And
Thank
so
you.
Mr. Sekele faced the charges that are detailed in paragraph 82 of your affidavit, correct?
Correct.
And so the chairperson of the disciplinary hearing for both of you made a ruling on guilt on the 4th of March, but he didn't give his reasons then, right?
Correct.
And he only provided his ruling furnishing full reasons on the 9th of March, correct?
Correct.
And then on the 11th of March, he requested both of you, as well as the PP, to make written submissions on mitigating and aggravating factors, right? For his consideration and sanction, correct?
Correct.
You say that on the 9th of April, he then informed you that he had provided his ruling on sanction to the attorneys of record of the PPSA, correct?
Yes, he informed us through our attorneys of record.
Right, but you only received his ruling on sanction on the 7th of May. When you received the PP's letter dated the 6th of May, where she stated her views about the sanction, right?
Yes, correct.
And you say in your affidavit that it was apparent from the PP's letter that she disagreed with the chairperson on sanction. And just for the committee, in relation to you, the chairperson had recommended that you be suspended without pay for a period of 3 months, coupled with a final written warning for 6 months, and that such a final written warning commenced after the expiry of the suspension, right?
Correct.
And in relation to Ms. Sekele, the recommended sanction was that she be suspended for 2 months without pay, together with a final written warning of 2 months, and that final written warning, commenced after the expiry of the suspension.
Correct.
But in the letter that you received on the 7th of May from the PP, you say it was apparent that she disagreed with the sanction imposed by the chairperson, right?
Correct.
And why do you say that?
Okay, the letter from the PP was very clear that she disagreed with the ruling of the chairperson because she felt that she had disagreed with the sanction imposed by the chairperson because she felt that the sanction was not appropriate to the misconduct in question. And the letter clearly indicated that the PP has imposed a sanction of dismissal, and she wanted us to provide us with reasons why she should not impose that sanction of dismissal.
Right. And this is the letter that was sent to you by the PP. This is the wording of that letter, correct?
Yes, that is the wording of the letter.
And she says in paragraph 5, having considered the findings on evidence of the chairperson and the subsequent sanction imposed, I have decided not to implement the sanction imposed by the chairperson. I am of the strong view that the sanction imposed by the chairperson is not appropriate, apropos of the charge, the nature of the misconduct, the guilty verdict, and the breakdown of the relationship of trust between the employer and yourself. Thus, I am hereby imposing a sanction of dismissal with immediate effect, subject to receipt of your representations as stated below. It is apparent from the findings of the chairperson that the trust relationship between the employer and yourself has irretrievably broken down. Go down, Sepa. To this end, I'm affording you an opportunity to make representations on why a sanction of a dismissal would not be appropriate under the circumstances. And she gave you a period until the 18th of May for those representations, right?
Correct.
Did you make those representations to the PP?
No.
What transpired then?
We consulted with our attorneys and we decided to challenge the PP's decision because we felt, and we also sought legal advice, that the decision of the PP was not in line with the disciplinary code that was approved by the public protector. We felt that the decision of the PP was imposing an additional sanction over and above what was imposed by the chairperson, and it was subjecting us to a further action without following due process. And it was based on the fact that the disciplinary code, the clause is very clear that the chairperson shall submit a report containing the final sanction of the disciplinary hearing, firstly to the Chief Executive Officer in respect of employees on level 1 to 12, and the public protector in respect of employees on senior management. So myself and Ms. Sikele are part of the senior management. So the sanction was submitted, the report of the chairperson was submitted to the public protector for implementation. So we felt that it was not proper for the public protector to change the sanction that was imposed by the chairperson. So we applied for an urgent application in the Labour Court, seeking an order interdicting the public protector from changing the sanction imposed by the chairperson.
And did you succeed?
Yes, we succeeded. The court granted the relief that we sought and made the order as follows: that the PP was interdicted from invoking a secondary disciplinary process as she intended to do by her letter dated the 6th of May 2021. The PP was ordered with immediate effect to implement and comply with the final sanction as imposed by the chairperson of the disciplinary hearing dated the 8th of April 2021. The parties were to bear their own cost.
And you say in paragraph 97 that the PP served you with a notice of application for leave to appeal this judgment, an order, and on the 28th, that was delivered on the 28th of May, right?
Yes, we didn't hear anything from the office as from the date of the judgment of the Labour Court until on the 21st of June 2021, when the PPSA served us with a notice of application for leave to appeal. to the Labour Court against the whole judgment and order granted by Justice Tlotla Lemaje that was delivered on the 28th of May 2021.
And you say that the PP's application for leave to appeal was dismissed with costs on the 24th of July, correct?
Yes, that is correct.
And then she then addressed letters to both you and Ms. Sikele on the 10th of August, right?
Yes, it is correct.
Can you go to the letter, support PM 13, page 3985? Is that the letter that was addressed to you? Go down.
Scroll down, let me see. Yes, that is the letter.
Go down, Tsepo. Well, she told you that she was intent on not implementing the sanction imposed by the chairperson on the grounds that she had indicated to you in her letter of the 6th of May, correct?
Actually, Advocate, if we can go to the first paragraph, paragraph 2 states that please be informed that I am implementing the sanction imposed by the chairperson of the disciplinary process as directed by the Labour Court on the 28th of May. That is the first paragraph.
Yes.
And then
that's right.
The second one is the one that indicates that she was not intended
not to do so.
Yes. On the grounds canvassed in her letter of the 6th of May. And as such, the
dispute to tell you that the dispute had to be settled by the Labour Court before she could implement it, and the effective date of implementation will be the 12th of August. And she told you that you are to return to work on the 12th of November 2021. But
correct.
Nevertheless, yeah, advised you in paragraph 8 that she intended to review the sanction of the chairperson in the Labour Court, but that review would not affect the implementation of the sanction, right?
Correct.
Affidavit 905. Yeah. And you say in your affidavit, then on the 18th of August 2021, the PPSA filed an application to review the decision of the chairperson on sanction, which was the application that the PP had told you about in the letter we've just talked about, correct?
Correct.
Right. Can you tell the committee what has happened in relation to that application?
We defended the application for review, and all affidavits had been filed, and including the heads of argument. But on the 27th of July 2022, our attorney received a notice of withdrawal that was filed by the PP's attorneys, the public protectors, attorneys of record in this matter. The notice of withdrawal was withdrawing the application for review and was tendering the cost that we had incurred so far in defending the matter.
Okay. So can I just ask, to your knowledge, there have been other reports in the PPSA's office that have been taken on review and set aside, and including cost orders made in relation to those reports. To your knowledge, are you aware of executive managers and chief investigators having been disciplined as a result of those reports?
No, I only know myself, Ms. Sikele, and Mr. Madiba. So far, it's only the three of us that I know of.
Right. So in the next section of your affidavit, you deal with what you call, what you describe as the unhealthy working environment in the office. And you start this section by addressing the problem of the backlogs in the organization. You say in paragraph 103 that this is a major issue.
Correct.
Yes. Can you elaborate, please, for the committee on this issue of the backlogs and how it arises and what its root causes are, according to you?
I think I need to first start by stating that backlog has always been...
Just a pause, Ms. Mogaladi. We don't have an echo when you speak. We have an echo when Advocate Mayose speaks. But technically, when we check it here, your mic seems to be active and live at some point when we get that echo. It might be that you have increased your volume so high. Now we're speaking technically because there's no traffic around you. We've seen that. So you might want to reduce it a bit, but the echo comes from when she speaks, Advocate Mayose, not when you speak. And maybe after lunch we'll get earphones and so on. Those are the two advices I'm getting. I got this one from you, and now Advocate Mbofu can also be technical.
Yes, I'm qualified.
Thank you. Let's try that again. Continue, Advocate Mayose.
Yes. So, Ms. Mogaladi, we were in the section of your affidavit where you describe what you call the unhealthy working environment at the PPSA, and I had asked you to just address the committee on this issue of the backlogs that you talk about at the forefront of your affidavit.
Okay. The issue of the backlog in investigations, it is a challenge for everyone, for the public protector, for us as executive managers, for the investigators, as well as for the complainants, because when complainants approach us, they expect that they would get prompt service from us as the public protector. And it is a problem that historically has always been there in the organization. And from my own assessment, based on the annual reports and the various strategic plans that as an organization we've been putting in place, this issue dates back many years. When I looked at the annual reports and the strategies, I could see that as far back as 2014, we tried to come up with a plan to deal with the backlog. And backlog, in my view, is caused by many factors. One, in my view, is the lack of sufficient resources for the organization. Sufficient resources being the warm bodies to conduct the volume of complaints that we receive as an institution. And secondly, the financial resources to appoint more staff members. I think it is common knowledge that the current PP, including all the former public protectors, from time to time, they would raise the challenges that the organization is not sufficiently funded. Those challenges would be raised during either the presentation of the annual report to the portfolio committee, and even on annual basis, the accounting officers and the public protector would always make submissions for additional funding from National Treasury to fill the post so that we are in a position to adequately attend to the volume of complaints that we receive. And Another factor that leads to the backlog over and above the lack of sufficient resources is the complexity and the technical nature of some of the cases that we receive as a public protector. Most of the cases that we receive as an organization, we might find that you receive one complaint, but within that one complaint that you receive, you might be having several issues that needs to be investigated. Some of those investigations would be technical, because the Public Protector Act doesn't, any person can approach us and can lodge a complaint against any state institution. So the issue of the complexity of the complaints, and also some of the reasons that also contribute is the service delivery challenges in government and some of the department. We often find ourselves in a situation where, over and above, due to the capacity challenges in some state institutions, the volume of complaints that we receive increases. As a way of coping, we would try to come up with systemic challenges. We would take appropriate remedial action in the reports, but we don't get the full cooperation in terms of implementation and turnaround time in those institutions. So even though we might have conducted systemic investigation, we still get high volume of complaints. So the issues cumulatively lead to backlog. And it's not necessarily true that it's because investigators are not working. My view and my experience is this is one organization where people are really committed. They often go beyond the call of duty. Some people would even come to the office over the weekends. Some would work long hours just as a way of trying to cope with the workload and the backlog. So that is my view on the backlog. And from time to time, like I said, in the strategy, we would set out the targets that would try to eradicate the backlog. It would be cascaded back to the individual performance agreements of the managers as well as the investigators. But we still find ourselves in a situation where we still have the backlog. But there has been several interventions to try and deal with the backlog. But we still find ourselves in a situation where we do have the backlog. Thank you.
So you say in paragraph 106 that in order to deal with the backlog and move investigations along from time to time, there have been various mechanisms, and I think that's just what you've alluded to now. Can you elaborate on that, on those mechanisms that have been devised from time to time to try and address the backlog?
Okay. The mechanisms would start with the strategy that would set a target for dealing with the backlog cases. Initially, we started by saying we want to finalize all the backlog cases by the end of the financial years. It was not working very well. Then we realized that I think we were not realistic about the targets that we had set. And then in the later years, the target went down to 80%. And as part of monitoring the performance, we used to report at the dashboard meetings as executive managers. Dashboard meeting is a meeting of the public protector with all the executive managers. Initially, we would report on the cases that fell outside the defined turnaround times. So we have 3 different turnaround times for finalizing investigation. For complex good governance and integrity matters, it's 36 months. The normal GGI matters would be 24, service delivery 12 months, and 6 months for early resolution. So at the dashboard initially, we would be reporting on the cases that fell outside these turnaround times, and there would be, and also cases within, in terms of the Executive Members Ethics Act, complaints lodged in terms of this act must be finalized within 30 days. So we would always regard those that went beyond the 30 days as being part of the backlog, and we would report quarterly. Initially, the dashboard was quarterly and it was changed to monthly. We would report on those cases, the progress that has been made on those cases.
And so in paragraph 109, you describe again what the dashboard meetings were about. And we've heard from various witnesses before about the dashboard meetings and what they would be about. And you say that executive managers there would present their unit's performance and present what strides would be made to deal with the backlog. And they'd give an overall picture of the unit's performance and so on and so on.
Correct.
But they say in paragraph 110 that when you came back from suspension, you noted or noticed that during dashboard meetings, the focus had changed and it was only around, your focus had changed. Can you elaborate more on that for the committee?
Okay, thank you. Before I went on suspension, as mentioned earlier, our focus was reporting only on cases that were older than 2 years and the different strides. But when I came back, firstly, the reporting expanded to all current matters in the organization. And when you presented the report, you would have to indicate on each case what product is expected. The product would either be, if it's a new complaint, you would have to indicate when is an allegation letter going to be issued. If you have to issue a subpoena on the matter, it would be the date of such, or if it's a section 7.9, you indicate section 7.9 by date so and so, report by date so and so. So it was no longer as in the past where we would interrogate these matters, but you would have to answer the two questions were to say what product is expected, being one of those four, and then the next question would be a date by when. But also,
so what's the problem with that?
The difficulty with this is that, firstly, there would be a target date in terms of when this matters would have to be dealt with. Let's take, for instance, my first dashboard when I came back from suspension was at the end of January, and clearly at that dashboard, the decision was that, for instance, with all cases that are out of timelines, they have to be finalized by the 31st of March, which was in 2 months. So the difficulty with what product is expected and by when is that you look quantitatively on the side of issues without looking at the qualitative issues, such as one, what kind of product, the complexity of the case that you are dealing with. Are there any challenges around the investigation in terms of the deliverables? Because this mainly only defined the deliverables and the due date, but did not take into consideration the overall risk as well as the challenges that might come across, and also the complexity of the matters that are being investigated, and also even in terms of the product or the deliverable that was expected. What would it take for the investigator to deliver that? So for me, that was one of the things that was a challenge. I really felt as if, look, we're just going through the run of the mill where we're saying people would just say date so and so, and it kind of created challenges for me because it's easy to put those deadlines, but when you go back to the reality of going to the files, it becomes something else. So because you have to look at the complexity and also what is important is that you need to look at the volume of evidence that has been produced, and also it also did not take into consideration the number of cases that were on hand with the different investigators at the time, because there was a situation where you might find that, I mean, one person was dealing with about 15 complex investigations that were on hand and that they were expected to finalize by the end of March.
So Mr. Futana Tebele in his evidence said that what the PP was expecting was people to comply with their own self-imposed deadlines, and that there was nothing unreasonable about that. Do you have any comment to make to that?
Look, in my view, a deadline is a process where you don't just look at the end date, you look at the circumstances of each case, you analyze each case, and then you take into consideration the various milestones that are expected to be delivered in the particular deadline. But in this process that we embarked upon, we were tied to a certain time period where, for instance, it would be, say, all cases older than 2 years must be finalized by the end of March. So if I come in at the end of January and I'm told that, yes, set your own target, but know that you must finalize all these cases by the end of March, it is not reasonable, it is not realistic, because I find myself in a situation where I am confined within a certain time period, and it did not take into consideration the circumstances or the complexity of the cases that was being dealt with. So for me, I think setting of own targets was, for lack of a better word, I would say it was superficial setting of own targets, because it always had an end period that you were confined to. And the individual contents of the respective files did not really matter. You had to comply with those timelines.
And is this what you are alluding to in paragraph 112 of your affidavit, where you say 3908, where you say the PP demonstrated no interest in these factors, and this is with reference to what you say in paragraph 111.
Yes, that is my.
Is this what you are talking about? That the targets that then become set do not take into account all of these factors?
Correct.
All right. So, Chair, I'm about to start a whole other line of questioning around from about paragraph 114, which deals with an email trail that's going to take a bit and that needs to be followed. I wouldn't like that to be interrupted, so I'm suggesting, Chair, through you, that perhaps this might be an opportune time. Come back 7 minutes early.
No, thank you. Those times are set. Thank you. We will pause there, and then when we come back from 2, we will stretch you up until 3 with everything else that you have, if you are able to do that. So the time now is just 5-6 minutes before 1. We'll take a 5-minute early lunch break and be back at 2. Thank you very much.
Thank you, sir.
Recording stopped.
First more cost order. Yeah.
Your microphone is on.